Hey, everybody, welcome back to the internet where your cesspool is my jacuzzi. Um, so, we have another docket update in the Blake Lively versus Justin Baldoni legal saga. Um, some wild stuff is included in this filing. It's a proposed protective order. However, it shows some really unfortunate stuff that at least one of the proposed witnesses has been subjected to. And I think this brings about a larger conversation about how nuts. I'm going to try not to swear in the beginning of this video because I'm trying not to get demonetized yet again. But how nuts people on the internet really are. And I'm totally not talking about you guys. So don't take that personally. But I am talking about some people, namely people on Instagram, because people on Instagram go buck wild in the comments. And apparently, like I said, one of those witnesses was threatened with some extremely heinous stuff. So we're going to go over that. Bruce, do you want to join me? I don't know if you're awake, but I'm going to send a link to Bruce real quick just in case, because we always love to hear from Bruce if we can. Anyways, we went over earlier another update to the docket. There were 3 today. So there was that motion to dismiss Justin Baldoni's amended complaint. And then there was the addition of Jed Wallace to the lawsuit, basically, is what it was. So a lot going on today, even though it seems like not very much. Quietly, I guess, a lot went on today. Let's see, 1 second. And guys, I just want to say, like I keep telling you guys, I'm not a professional content creator, so the purposes of my stream, they're more like conversational. I can give you perspectives from like a mental health professional, but I can't give you perspectives from a lawyer or a judge. So the same stands, but I will tell you this. It is 1:30 in the morning here in Florida, where I live. And I will work very hard to see if one day I could make this a career, and then I won't be so unprepared for my live streams. But right now I work a 9 to 5. I work 2 part-time jobs, and I have school. So, lots of stuff going on. I'm basically just stalling while I invite my friend Bruce here. There we go. Okay. Bruce, hop in if you want to. If not, that's fine. Blake turned her IG comments back on to collect more evidence for her next refile. I didn't know they were off. I honestly, guys, the thing is, like, I don't feel any sort of necessity to go and comment on a celebrity's Instagram. If I'm commenting on someone's Instagram, it's almost always someone that I know. So I did read some of the comments on her Instagram earlier, and I was like, wow, people really like are bored. I don't know, because like even though I don't necessarily like her based on what she's done, I don't really know her as a person. Therefore, I would never go to her Instagram and post comments on there and be rude. You know what I mean? So it's just, yeah, I don't know. Amy Walker says Blake leaked the names. I don't know if we're talking about the same people though, so we're gonna go and take a look at that, and we can all make our assumptions then. How about that? Okay. Share this with you guys real quick. Everyone, I just want to say thank you again to my Bacon Army members who are here tonight, because if you don't know what Bacon Army is, someone in the chat should tell you. All right. Here we go. February 20th. That was technically yesterday now, but hey, I'm still awake, so it's kind of today. Dear Judge, the court instructed the parties to submit a proposed protective order no later than March 11th, and if the parties are unable to reach an agreement, to file competing versions by the same date. All of the parties, including the plaintiffs in the Wayfair case, agree that a protective order is appropriate here, and that the court should, at minimum, enter its model protective order. Exhibit A, the Wayfair parties are amenable to the court's model protective order. Okay. Blake Lively, Ryan Reynolds, Leslie Sloan, and Vision PR, collectively moving parties, agreed that good cause exists for the court to provide additional protections beyond those contemplated in the model protective order by entering the proposed protective order attached here to as Exhibit B. Okay. The proposed PO differs from the PO is protective order, guys. The proposed PO differs from this court's model PO primarily by adding the following: an attorney's eyes only category, which applies to confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, personal, or privacy injury. That is a lot of words, sorry. Specific examples of categories of discovery material that may qualify as confidential or AEO discovery information in a case of this nature, including, for example, previously non-disclosed information unique to the entertainment industry, such as, for example, creative ideas or client relationships, or information of a personal or intimate nature in a case involving high-profile individuals, and we have that for sure, and allegations of sexual harassment, and we have that, whether you agree with it or not. Personally, I don't buy it, but the allegations are there. A limitation on who can receive materials designated as AEO, which is, again, attorney's eyes only, and an emphasis on the restriction on publicizing discovery material. Okay. See real quick. Okay. It would be well within this court's discretion to provide the heightened degree of protection contemplated in proposed PO pursuant to Rule 26C of the Federal Rules of Civil Procedure, which provides that a district court may, for good cause, issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Okay. Courts in this circuit have noted that, for purposes of protective order, good cause is established when a party is able to show that a clearly defined, specific, and serious injury will occur in the absence of such an order. Okay. Good cause exists for the court to adopt the proposed PO. The court need not speculate whether a clearly defined, specific, and serious injury will occur in the absence of the proposed PO, because a defined, specific, and serious injury already has occurred in the absence of one. As detailed in Ms. Lively's amended complaint, Ms. Lively, her family, other members of the cast, various fact witnesses, and individuals that have spoken out publicly in support of Ms. Lively have received violent, profane, sexist, and threatening communications. For example, in the days after January 31st, when the Wayfair plaintiffs filed their amended complaint, so Justin's amended complaint, including a 100-plus page exhibit with text threads, one fact witness known to publicly support Ms. Lively and whose text the Wayfarer parties excerpted, ostensibly without his permission. So you guys in the comments can guess who he is, I guess. It says ostensibly without his permission, received a written threat indicating that the witness's family would be sexually assaulted and killed unless the witness agreed to make a statement and give the truth. And that's fucked, guys. Like, that's so warped. I can't believe, like, imagine actually saying that to somebody. Like, these are real people, you know? And that's a really scary thing. Like, imagine if you got a threat like that. So, it's just crazy. Damn. It's just crazy. Ness, the court of random opinion, who's filing this, Blake or Justin? Well, it's a proposed protective order that was agreed upon by both parties, but I think technically the Lively parties are moving for this, but they did go back and forth and agree on it. All right. So I just want to remind everyone, that no matter how crazy or upset you're feeling, it's not okay to send death threats to people, even if you don't like them, or even if you don't like what they did. So, yeah. All right. Around the same time, Ms. Lively became the target of pornographic trolling on Instagram, so vicious that Meta publicly stated that the kind of online harassment is wrong and we condemn it. See Blake Lively Instagram flooded with porn amid Baldoni war. Meta condemns the harassment. TMZ, January 31st. It is entirely, wow, I can't believe I just said that. It is entirely foreseeable, probable, and inevitable. I said entirely improbable like they had a baby. um, and inevitable that the release of certain discovery information, including of the type that the proposed PO specifies as deserving protection, will create a defined, specific, and serious injury to parties and non-parties, such as by violating their privacy, exposing them to threats, and creating a climate of possible witness intimidation. Those potential injuries, coupled with the threats to the efficient administration of justice, establish good cause to extend protections to specific categories of non-public, private, business, and personal information. There we go. There's a footnote here. Hang on, let me see where that context was. So number 3. This is citing some case law, so I'm not going to go over that tonight, guys. Here's footnote number 5. As the court is aware, this litigation has drawn widespread media attention, especially by the Hollywood press. Well, you don't want to talk about the Hollywood press right now. All right. And tabloid media. And at a hearing on February 3rd, the court acknowledged the necessity of a protective order given the number of high-profile people involved in this case. Okay. Right. Good cause exists for an AEO designation for highly confidential information of a personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, personal, or privacy injury to the producing party. I'm skipping over some of the legal jargon here, guys, because I want to let my friend Omar, the lawyer, or some other law tubers go over that stuff, but we're just going to get through the meat of this tonight. Because it is, again, 1:30 in the morning here. All right. Let's see. Got through that. An AEO category is paramount where, as here, litigation involves claims of sexual harassment in the workplace, lest victims of sexual harassment be forced to disclose highly sensitive personal information directly to the harassers. Additionally, the Lively case rests on allegations that the Wayfarer plaintiffs launched and continued a retaliatory smear campaign in order to destroy and bury Miss Lively, funded by a defendant who committed $100 million to protect the studio like Israel protected itself from Hamas. Oh, good. We're doing that again. Okay. There were 39,000 dead bodies. There will be 2 dead bodies when I'm done. Minimum. Not dead, but you're dead to me. So that kind of dead, but dead to a lot of people. Stop saying dead, guys. But dead to a lot of people. If they ever get me to that point, then I'll make it worth their while because I'm going to spend a lot of money to make sure the studio is protected. I got to tell you, I don't love the comparison to Hamas. But you are allowed to defend yourself, right? And not even violently. I'm talking about he's using words, right? He's specifying not dead, but dead to me. And we all know dead to me is hyperbolic. It's not like a literal thing. He's not literally going to kill someone. I hope not. If he does, then I'll come back here and eat my words. But Dave, you're awake. What's going on? Bacon Bandits. How's it going, man? I was just about to text you, but then I got caught up, so I was going to do it after. All right. Dave, my friend, if you're not following his channel, Dave is my friend who got me started on YouTube, so you should definitely follow him. All right, let's see. So we got through that. The court can minimize the probability of harm, oppression, or invasion of privacy by adopting an AEO designation that protects parties and third parties from delivering their most personal and sensitive materials directly to a group of individuals who are committed to weaponizing information at their disposal for use in a crisis communications combat plan. Courts in this district find a good cause for an AEO designation when disclosure would unnecessarily violate the privacy rights of a particular person or individual. Okay. Footnotes here again are all like case stuff, so I'm gonna respectfully submitted, and then there's Blake's lawyer right there. All right, we have Exhibit A here, external email, and this is from Kevin Fritz to who are all these people? Hang on, Brian Friedman, whatever, blah blah blah. So basically, it's from the Lively parties, one of the lawyers, to the Baldoni parties or the Wayfarer parties. Okay. It says, Kristen, with respect to the Lively party's request for a protective order, the Wayfarer parties are amenable to the court's model protective order without the Lively party's proposed changes thereto. Okay. All, I hope you had a restful holiday weekend. I am resending the draft protective order to include newly noticed counsel and counsel for the related case. As discussed during the meet and confer last week, the Lively Reynolds parties have proposed the attached protective order for the consolidated cases. We understand from last week's correspondence and discussion that the Vision Sloan parties agree to this draft and that the Wayfarer defendants do not intend to seek any protective order. Will counsel for the Wayfarer defendants please confirm that you do not intend to seek protective order? Additionally, at the parties' February 3rd conference with the court, the judge had inquired as to whether the protective order will also expand to cover the related parties. Will counsel for the parties in Jones v. Abel please indicate whether you intend to seek a similar protective order? Please advise of your positions by 12 p.m. Eastern tomorrow. In light of the upcoming disclosures, we believe it's important to seek a protective order promptly and plan to file with the court early this week. Best, Krista. Okay. And that was... Where's the date on this thing? Monday, February 17th. So that was earlier this week. Right. Here we have Exhibit B, which is the protective order, the proposed protective order. Techie Bliss, thank you for the $4. I appreciate you. All right. Making tomorrow's content. Oh, yeah. Dave's always up making something. The guy's a dad, so he's juggling all those kinds of things. All right. Let's see. Whereas all of the parties to this action, collectively the parties and individually a party, request that this court issue a protective order. I don't know if you ask the cart, they might not do anything. Pursuant to Federal Rule of Civil Procedures, 26C, to protect the confidentiality of certain non-public and confidential material that will be exchanged pursuant to and during the course of discovery in this case. Whereas the parties, through counsel, agree to the following terms. Okay. They acknowledge that this protective order does not confer blanket protections on all disclosures or responses to discovery, and that the protection it affords only extends to the limited information or items that are entitled under the applicable legal principles to confidential treatment. Okay. Whereas the parties further acknowledge that this protective order does not create entitlement to file confidential information under seal, and whereas, in light of these acknowledgments and based on the representations of the parties, that discovery in this case will involve confidential documents or information, the public disclosure of which will cause harm to the producing person and or third party to whom a duty of confidentiality is owed. And to protect against injury caused by dissemination of confidential documents and information, this court finds good cause for issuance of an appropriately tailored confidentiality order governing the pretrial phase of this action. I'm so tired. All right. It is hereby ordered that any person subject to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of the protective order shall adhere to the following terms. 1. Any person subject to this protective order who receives from any other person subject to this protective order any discovery material, example, information of any kind produced or disclosed pursuant to and in course of discovery in this action, that is designated as confidential or attorney's eyes only, which is AEO, pursuant to the terms of the protective order, shall not disclose such confidential discovery material to anyone else except as expressly permitted hereunder. The designation, attorney's eyes only, shall only be utilized for confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, or privacy injury to the producing party. As follows, the protections conferred by this order cover not only confidential and attorney's eyes only information, but also any information copied or extracted therefrom, as well as all copies, excerpts, summaries, or compilations thereof, hereinafter. I hate when they use all these words within words. God damn legal writing. Okay. Hereinafter, referred to collectively as copies, plus testimony, conversations, or presentations by parties or counsel to or in court or in other settings that might reveal confidential or attorney's eyes only information. This is all just so wordy. It's even wordier at 1:42 in the morning. So Caleb Gay. I love your last name. Thank you for the $2. Thank you. I appreciate you. All right. He says, on information and belief, my new favorite phrase. All right. Let's see. Hang on. Okay. Thank God for this giant water bottle, guys. Where did I leave off? I know there were a lot of words that were within words, and I got distracted by bitching about it. Okay, we were there. We went through that. The person producing any given discovery material may designate as confidential or attorney's eyes only such portion of such material, the public disclosure of which is either restricted by law or will cause harm to the business, commercial, financial, or personal interests of the producing person and or a third party, including high-profile individuals to whom a duty of confidentiality is owed, and that consists of A. Previously non-disclosed financial information, including without limitation profitability reports or estimates, percentage fees, design fees, royalty rates, minimum guarantee payments, sales reports, sale margins. Guys, I'm not going to lie to you. This is all a lot of financial stuff that I just don't care about. B, previously non-disclosed material relating to ownership or control of any public or non-public company. C, previously non-disclosed business plans, product development information, marketing plans, trade secrets, creative ideas, film scripts, projects, productions, entertainment activities, and other creative or artistic matters, client relationships, or communications regarding business affairs or contractual negotiations. D, any information of a personal or intimate nature regarding any individual, including but not limited to photographs, videos, or audio recordings of family or other personal relationships, non-public information regarding the identity and nature of personal relationships, medical, mental health, and or healthcare records, social security numbers, or non-public contact information, including but not limited to telephone numbers, email addresses, physical addresses, or whereabouts or code names for the hotel use. Extracts or summaries of any information identified in A through D, and any other category of information herein after. Oh my God, there's another one. Here and after, given confidential status by the court. All right. With respect to the confidential or attorney's eyes only portion of any discovery material other than deposition transcripts and exhibits, the producing person or that person's counsel may designate such portion as confidential or attorney's eyes only by A, stamping or otherwise clearly marking it, or B, producing for future public use another copy of said material with the confidential information redacted. Okay. With respect to the deposition transcripts, a producing person or that person's counsel may designate such portion as confidential or attorney's eyes only, either by A, indicating that on a record during the deposition that a question calls for confidential discovery, B, notifying the reporter and all counsel of record in writing within 30 days after a deposition has concluded of specific pages and lines of the transcript and or the specific exhibits that are designed or designated, confidential or attorney's eyes only, in which case all counsel receiving the transcript will be responsible for making the copies in their possession or under their control as directed by the producing person or that person's counsel by the reporter. If at any time prior to the trial of this action, a producing person realizes that some portions of discovery material that she, he, or it... Wait, what? Okay. She, he, or it, I guess, had previously produced without limitation should be designated as confidential or attorney's eyes only. She, he, or it may so designate by so what does that mean? He, she, or it. A producing person realizes that some portion she, he, or it. I mean, all right. Most people don't want to be called it, but maybe they mean the material. Okay. May so designate by so apprising all prior recipients of the discovery material in writing, and thereafter such designated portions of the discovery material will thereafter be deemed to be and treated as such under the terms of this protective order. Oh, now Omar texts me back. Jesus Christ. Hang on. Hang on. Let me email my friend Omar, the lawyer, a link here. just in case he can join us. Because he can translate a lot of this stuff that I can't. I know my limitations, so... Natasha, very good. Thank you for the $16.99 super sticker. You're awesome. Appreciate you. Let's see. Let's get that link real quick. I have this intrusive thought every time I go to copy the link for StreamYard that I use to stream to like give it to somebody to get on the stream. I have this intrusive thought that I'm going to accidentally put it in the live chat to have like everybody pile in at once. Oh man. All right. Where were we at? Well, until and unless Omar gets here, I'm taking these headphones off because they're just getting a little hot. Okay. No person subject to this protective order other than the producing person shall disclose any of the discovery material designated by the producing person as confidential to any other person whomsoever, except to A, the parties to this action, their insurers, and counsel to their insurers. B, counsel retained specifically for this action. C, outside vendors or service providers that counsel hire and assign to this matter. Including computer service personnel performing duties in relation to a computerized litigation system as reasonably necessary, provided such vendors or service providers have first executed a non-disclosure agreement in the form annexed in as an exhibit here too. Okay. Any mediator, or arbitrator that the parties engaged in this matter or that this court appoints, provided such person has first executed an NDA. As to any document, its author, its addressee, and any other person indicated on the face of the document as having received a copy, any witness who counsel for a party in good faith believes may be called to testify at trial or deposition in this action, provided such person has first executed a non-disclosure agreement in the form annexed as an exhibit here too. Okay, hang on. Let me think about this for a second. Any witness who counsel believes may be called to testify, provided they first executed an NDA. So no person subject to this shall disclose any of the discovery material. So I'm just asking a question here, guys, because you guys know I'm not a lawyer. Does that mean the two women that Blake alleged also made complaints against Justin, seeing as they came to this agreement before today, like they came to this proposed agreement before today, does that mean that any witness, they couldn't say anything or disclose this information to the public before, I guess, trial, or if they signed an NDA? I'm just asking a question. Like I said, you guys know my channel is more conversational. I'm not a lawyer, so. Anissa, thank you for the $10 super sticker. I appreciate you. I'm coming. Omar, keep that to yourself. Haven't you learned anything from these false allegations? You don't just tell people that. Oh, guys, my lawyer friend will be here in a minute. All right. And then he can tell us what that means because he actually understands. And then I guess I better put my headphone back on. Omar's coming, everyone. Well, we need Omar to decipher the legal stuff for us. The tired lawyer. That tracks. Well, Omar is out in California, so luckily for Omar, it's well before midnight right now, but it's 2 a.m. here for me, pretty much. All right. We'll keep going until he gets here. And we'll earmark that. We're at that was number, well, it was letter D. How about that? Not D, F, sorry. Okay, so let's move on to G. Any person retained by a party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provided such person has first executed an NDA. H. Stenographers engaged to transcribe depositions conducted in this action. And I. This court, including any appellate court, and the court reporters and support personnel for the same. There's a footnote here. It says, in the event the fact witness refuses to sign a copy of the exhibit, he or she may be shown confidential discovery information only after on the record stating such refusal, and then being advised on the record of the following. By order of the court in this action, you may not disclose in any manner any confidential discovery information to any person or entity except in strict compliance with the provisions of this order. And if you do so, you may be subject to a sanction by the court. All right, we're moving on to 7 here. With respect to discovery material designated as attorney's eyes only, such material shall only be disclosed to those persons identified in paragraphs 6b, c, d, e, g, h, I. Let's just put all the letters, okay? But shall not be disclosed to the parties. Okay. Prior to any disclosure of any confidential or attorney's eyes only discovery material to any person referred to in paragraph 6, c, d, f, g, such person shall be provided by counsel with a copy of this protective order and shall sign an NDA in the form annexed as an exhibit hereto, stating that the person has read this protective order and agrees to be bound by its terms. Said counsel shall retain each signed NDA, hold it in escrow, and produce it to opposing counsel either prior to such person being permitted to testify at deposition or trial, or at the conclusion of the case, whichever comes first. All right. S16 Gallery says it means she does not have to publicly name them, but can have them testify in trial. Okay, yeah. I think it really shows is that they are not backing her up, and she is just dragging. Huh. All right. Says, Ness, can you send me a link for membership? It's in the description of this video, guys. If you click on it, you should be able to find it there also. Okay. Any party who objects to any designation of confidentiality may, at any time prior to the trial of this action, serve upon counsel for the designating person a written notice stating with particularity the grounds of the objection. If the parties cannot reach agreement promptly, counsel for all parties will address their dispute to this court in accordance with paragraph 1c of this court's individual practices in civil cases. Well, I personally think that if the parties cannot reach agreement promptly, they should have to undergo ferret legging competitions. And if you don't know what ferret legging is, look it up. You'll regret it. Oh, man. A party may be requested to produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party or high-profile individual. Within 2 business days of receiving the request, the receiving party subject to such obligation shall inform the third party or high-profile individual of the request, and that the third party or high-profile individual may seek a protective order or other relief from this court. If neither the third party, high-profile individual, nor the receiving party seeks a protective order or other relief from this court within 21 days of that notice, the receiving party shall produce the information responsive to the discovery request, but may affix the appropriate controlling designation. Recipients of CDM under this protective order may use such material solely for the prosecution and defense of this action and any appeals thereto, and specifically may not use CDM for any business, commercial, public relations, media, or competitive purpose. Nothing contained in this protective order, however, will affect or restrict the rights of any person with respect to its own documents or information produced in this action, nor does anything contained in this protective order limit or restrict the rights of any person to use or disclose information or material obtained independently from and not through or pursuant to the federal rules of civil procedure, and keeping with the order by this court with respect to Rule 3.6. I don't know why I said that like I was so excited. I'm just really tired. Okay. All persons seeking to file redacted documents or documents under seal with the court shall follow Rule 2H of this court's individual practices in civil cases. No person may file with the court redacted documents or documents under seal without first seeking to leave to file such papers. All persons producing CDM are deemed to be on notice that the Second Circuit puts limitations on the documents or information that may be filed in redacted form or under seal, and that the court retains discretion not to afford confidential treatment to any CDM submitted to the court or presented in connection with any motion, application, or proceeding that may result in an order and or decision by the court unless it's able to make specific findings required by law in order to retain the confidential nature of such material. Notwithstanding its designation, there is no presumption that CDM will be filed with the court under seal. The parties will use their best efforts to minimize such sealing. Okay. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial or supporting or refuting any motion for summary judgment, even if such material has previously been sealed or designated as confidential. Any party filing a motion or any other papers with the court under seal shall also publicly file a redacted copy of the same via the court's electronic case filing system that redacts only the confidential discovery material itself and not text that in no material way reveals the CDM. Okay. Each person who has access to the discovery material that has been designated as confidential or AEO shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. Okay. Oh no. Okay. For the avoidance of doubt, no confidential discovery material may be publicized on the internet or used in communications that flow through the internet, including but not limited to via text message, Snapchat, Instagram, TikTok, Reddit, YouTube, or any other online social media platform. Wow, they really got Snapchat in there. Thank you, Sarah, and thank you, mods, for being here. Hey, Steph. Hey, Crow. All right. Guys, nobody move. We have 666 watching this live right now. That's like a perfect aesthetic for me. No, somebody moved. Damn it. All right. Oh, Aline says, trying to catch up, so I'm reacting to something that was said half an hour ago. Imagine having to remind people it's not okay to make death threats. Dude, I feel like it's happening constantly. All right. Any personally identifying information, PII. Okay. That should be a given, yeah. Exchange and discovery shall be maintained by the persons who receive such information and are bound by this protective order in a manner that is secure and confidential, including as addressed in paragraph 2E. 19. This protective order shall survive the termination of the litigation within 30 days of the final disposition of this action. All discovery material designated as confidential or attorney's eyes only, and all copies thereof shall be promptly returned to the producing person or, upon permission of the producing person, destroyed. All persons subject to the protective order acknowledge that willful violation of this protective order could subject them to punishment for contempt of court. This court shall retain jurisdiction over all persons subject to this protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. Woo! All right. And then here we have the NDA attached. Give me 1 second. I need to hydrate. Love your new channel name. Thank you, Nick. That's the name of my podcast. I'm trying to change it to my little tag name, that too, but it'll take a little bit. Juxtabanza says this reeks of you can't do this, and if you do, you're in trouble. And then they go and do it sneakily and blame Justin's team. Can't stop, won't stop. Real says, like Justin was not threatened or his wife not verbally attacked. Yeah, that's a good point. Good point. I guess I just want to say, like, it's so crazy to me that anyone would go to a celebrity's Instagram page or a bachelor contestant's Instagram page, a reality TV star, whoever, and make threats or say you deserve to die or say you deserve awful things or whatever. I'm like, God damn, even if you don't like the person, don't you have something else you could be doing right now? Like, come on. All right. I don't know if I read this earlier or not, but if I did, I'm going to get you twice. Anisha, thank you for the $10 super sticker. I appreciate you. And EC, thank you for becoming a YouTube member. You guys are awesome. Thank you. Okay. All right. Let me hide that real quick. There we go. And this is the NDA. It says, I blank acknowledge that I have read and understand the protective order in this action governing the non-disclosure of those portions of discovery material that have been designated as confidential discovery material. I agree that I will not disclose such confidential discovery material to anyone other than for purposes of this litigation, and at the conclusion of the litigation, I will either return all discovery information to the party or attorney from whom I received it, or upon permission of the producing party, destroy such discovery information. Okay. Here's the important question. Do they get to choose how they destroy it? Do they get to choose how they destroy it? If you're in the chat, I want to know, if you had to destroy discovery information after you used it, how would you destroy it? Would you set it on fire? What would you do? Like, hey, Omar.
Hey, Lauren. By the way, just, you shred it.
No, that's
most people do.
No, I want to do something dramatic.
You could light it on fire and then do like a little Indian dance and dance around the ashes.
We're getting there. We're getting closer. I would watch you do that. Let's put it that way.
With the ferret legging? Is that what you said? Is that what the ferret legging is?
Ferret legging? No.
Is it like a dance?
They said, wait, the ferret legging is a sport. It's a real sport.
What in the hell? Okay. In what country is that a sport?
Well, the videos I saw were from Britain. But
doesn't that figure? They got cheese rolling over there. Cheese rolling is like really big.
No, but I need to go hang out there. So basically, guys put ferrets down their pants and they compete to see who can keep them in there the longest.
Jesus, you win. You win.
You know what? Okay, chat, I'm sorry, but we have to watch this. Hang on 1 second. I have a clip of it that we have to watch. It's not very long, I promise. This is a short detour, okay? But Omar needs to know what this is, and so do you.
This better not be weird ass porn.
It's not porn, you
for the health of your channel is all I'm saying. You're coming up on 10,000 subscribers.
Look, man, I'm not into porn. I'm into ferret legging. It's different.
Who said that they're any different?
Me! I've seen both, haven't you?
The ferret porn out there on the hub.
All right, brief detour here, guys. You need to know what we're talking about. It's important.
So good. It in their pants.
Were merely going about their ferret business, exploring this warm, dark, and strangely convoluted new world they had found themselves in. Their natural curiosity often led to them wriggling deeper into the trousers, prompting gasps and laughter from the audience. There were also stories of ferrets that had become notorious for their ferocity, earning nicknames like the Claw or the Nipper.
I would have called him Marshmallow, Sparkle.
No, in my luck,
Here's another dumb one I found. Using a beach ball.
That was like right when I started YouTube, man.
That was the cesspool that you were talking about.
It really was. I really dove into it. Oh my gosh.
I think if you wear underwear, it's cheating, Jacqueline.
Is it?
Otherwise, what fun is it to have a nipper? Or a claw? Or whatever that guy said. That guy made it sound like so sophisticated. These weird kinks they have over in England, along with the cheese rolling.
Good Lord.
Anyway, what are we on about tonight, man? What's going on?
All right, so this is like a proposed protective order filed by, I guess some parties agreed on this, but the gist of the dramatic stuff at the beginning was, let's move back up to that page, actually, and we're on 16 now. We'll start back over on that in a second. So it said here, Good cause exists for the court to adopt the proposed PO. The court need not speculate whether a clearly defined, specific, and serious injury will occur, because a defined, specific, and serious injury already occurred. As detailed, Ms. Lively, her family, and other members of the cast, various fact witnesses, and individuals that have spoken out publicly in support of Ms. Lively have received violent, profane, sexist, and threatening communications. For example, in the days after January 31, where the Wayfarer parties filed their amended complaint, one fact witness known to publicly support Miss Lively and whose text the Wayfarer parties excerpted, ostensibly without his permission, received a written threat indicating that the witness's family would be sexually assaulted and killed unless the witness agreed to make a statement and give the truth. So, that's nutty.
Wait a minute. Who threatened who?
I don't know. I don't know who. We don't know who made the threat.
One fact witness known to be publicly support Miss Lively, whose text the Wayfarer parties excerpted, received a written threat. So some crazy guy says you will be essayed and killed unless the witness agrees to make a statement and give the truth. Yeah. So this is a stipulation to a protective order. So why are they giving this long explanation then?
I don't know.
I mean, like, if we agree and the judge agrees, like,
somebody says here, hang on. Somebody says here, they didn't agree to all of this. Okay. So they agreed to the standard gag order, but Blake wants everything under seal. All right.
Oh, so I guess this is argument to keep it under seal.
Lame.
Well, that would be a whole lot of, that'd be pretty anticlimactic. That would be.
Dude, right? I mean, hello, I'm going to be bored.
Yeah, under seal. Nah, I don't think they're going to keep this under seal. They haven't identified any witnesses. That, I guess, is some explanation why. They keep on saying other women and other people without identifying. I guess that kind of makes sense. Now there's underlying reasons for it. So, okay. They could keep these people anonymous, but as far as keeping the proceedings under seal, I mean, that's a bridge too far, I think.
Yeah.
It seems like the protective order, the protective measures they're stipulating to would be sufficient to offer the appropriate protections. Is this what this is all about? This is what I've been summoned for. You gave me the bat signal to talk about a stipulation.
No, I just wanted to talk about ferret legging.
Oh, okay. Well,
I gave you the bat signal an hour ago. We're long past that.
We're
in the shitter now. All right.
Ferret nippers.
All right. So we want to clarify that. What did they actually agree on this or not? Hang on. Let's see. The court instructed the parties to submit a proposed order if they're not able to reach an agreement to file competing versions. All of the parties, including the plaintiffs, agree a protective order is appropriate, and the court should, at minimum, enter its model protective order. Okay. Blake, Ryan, Leslie, and Vision, okay, agree that a good cause exists for the court to provide additional protections. All right. The proposed PO differs from this court's model PO primarily by adding the following. An attorney's eyes only category, okay, which applies to confidential discovery material.
No.
All right. Specific examples of categories of discovery material that may qualify as confidential or AEO discovery information in a case of this nature, including, for example, previous non-disclosed information unique to the entertainment industry. Okay, whatever. So I'm just trying to figure out. This is because it looked like it was jointly filed. That's why I'm confused.
Well, I think that there is a mutual need to not have this debated the way that it's been debated for the last month.
Yeah. Because
it's not doing either of their careers any favors. I mean, arguably, you could argue that Justin's kind of coming out ahead because he is largely, the majority sees him as a victim in this case.
It seems that way.
But on the other hand, Lively, her career, if it ever recovers, it's going to take a while because of people forming their own opinions. But then it's like
no, they're all bots.
You're standing on top of the Empire State Building with a pillow full of feathers, and then you release the feathers and just drop them out. There's no unringing that bell. And so what's done is done. The public knows, and this protective order will serve to seek the witnesses, protect the witnesses. It will serve to maybe temper the rising flames of vitriol from trolls threatening to essay prospective witnesses.
Yikes.
That would be a good thing. But to keep it under seal, no, I think if I'm Friedman, I want to keep on fighting this out in the public. I don't want.
Okay. So I was just looking at Pacer. Give me 1 second. So it looks like it was just filed by Blake and Ryan. What's that?
Did you sign up for Pacer?
I signed up for Pacer ages ago, dude.
Yo, that is commitment. I refuse.
Really?
I refuse. I'm not paying them money for stuff that I could get readily on the internet for free.
I mean, you could, but it would take like 2 minutes longer.
I mean, Reddit is a vast resource of these pleadings I found.
Well, our comment friend there was right. This was actually filed by Blake, Ryan, and the lively parties. It was not agreed upon by both. I thought it was, and that was my mistake. I just got confused in the beginning because it was actually 1 o'clock past when I started this. So I'm very tired and I'm very not a lawyer.
So just my take on it, it just sounds like, I mean, I know it sounds like stuff, but it just sounds like there is a model protective order that they defined. They wanted to add additional provisions to the model, and they disagree on further protections above that. That's the gist.
Okay. All right. I mean, if you put it that way, it sounds a lot simpler than whatever the fuck I just read.
Well, lawyers just like to, they pretend like they're saying stuff, but that's literally all it was.
Are you sure? Because I heard wherefore throughout motherfucker dumb. I don't know. There was a lot of words there.
What in the hell are you on?
What am I on?
No, I don't.
I'm on page 13. You dickhead.
I have not 13 pages.
What?
Well, I didn't read all the paragraphs. I literally deciphered that from paragraph 1. And so I guess these other paragraphs are the reasons why they disagree about additional protections. Is that where we're going with this?
Your guess is as good as mine, brother.
It might be a little better than yours because
no, because I knew the ferret thing. So yeah.
You know the ferret thing.
We have the same IQ now. It's fine. It's fine.
Oh boy.
All right, let me see. Let me see here. We got through this. Party may be requested to produce discovery material subject to contractual or other obligations of confidentiality. Okay, I'm not going to read that jargon. Okay. Recipients of confidential discovery material may use such material solely for the prosecution and defense of this action, and any appeals thereto, and specifically may not use confidential discovery material for any business, commercial, public relations, media, or competitive purpose.
So don't break the protection of order.
So nobody's allowed to send me direct emails with your documents. I mean, maybe before the judge signs this, hey everyone, I'm available. My email is in my YouTube file.
People via Twitter, that kind of stuff.
Leak your trauma to me before it's too late, guys. All right.
That's why they published that timeline, because I think they foresaw a decision like this from the judge where he's going to keep everything under wraps. And so they got in their haymakers when it was still legal to do so.
Haymakers?
Oh,
what's a haymaker?
Man, it is a Mike Tyson left hook, a Joe Frazier left hook when he knocked down Muhammad Ali circa 1975.
Haymaker?
Yeah.
All right, I'm going to look that up later.
Well, just don't be careful what links you click on if you're going to be looking up haymakers.
Well, I'm not going to do it on stream, am I?
I mean,
I know you're kind of perverse, so I'm not going to look up any suggested things that you tell me on stream.
I can't do your computer screen. So.
Cass, thank you for the membership, and I'm sorry that you did that because now you know we're weird. Okay.
Well, we come here for the weirdness, I feel,
I mean, yeah. I mean, it was pretty normal until you got here, though. So
you can only hear educational talk for so long about. I mean, who really gives a shit about protective orders in a Justin Baldoni case?
Me, apparently. It's fucking 2 a.m. So...
Well, you are a beast, man. You've been on one, but I'm so proud of you, man. You're about to hit 10,000K subscribers, and you're like you're the hardest working person on YouTube that I know.
Dude, I don't know. So I got off work at 5, and then I what did I do after that?
Was it yesterday? Were you up till 4 a.m. streaming?
No,
Or was it the day
yes,
before?
technically it wasn't yesterday now, it was the day before that, but I don't know because the time is all off. Yeah. So what did I do? I got off work at 5, and then I went and did a docket update on the Jed Wallace thing that came out because I got a pacer alert on that.
What's the thing
What was
about Jed
that?
Wallace again?
Jed Wallace. So the Jed Wallace and the crisis PR firm that Justin allegedly hired, Blake Lively did not name him in the original complaint, and she had filed a 202 motion for like a deposition or something. And then he, hit back at that with a lawsuit basically for defamation and something else. And one of the main points that they put in there was that Blake hadn't named them in the actual lawsuit because she knew that she didn't really have anything on them and that it wasn't true. And then now in the amended complaint, she did include him in there. So today they actually put in the request to have him summoned.
You sue me, I sue you.
Yep.
And by the way, that is a strategy sometimes where, look, when you write these complaints, you see like that little tagline, does 1 through 50. It suggests that investigation is ongoing. We're still looking into things. And it's quite possible that we could add additional defendants, and these does 1 through 50s are placeholders for prospective other defendants. And so it's not impressive to me that they left them out of the original complaint. That's happens all the time.
Okay. Who's saying, let me see. You're on court listener, right?
I ain't on any of this shit. I'm on all of the stuff that I practice in all of my jurisdictions.
I'm gonna help you soon. Okay, because I mean I got all the deets about how to get this stuff and what ferret legging is and all that.
I mean, for these
stuff.
cases,
I mean, your law degree is fine, but I can do ferret legging and shit.
I'll do the ferret legging. People usually just like, hey, could you talk about this? All right, sure. Justin Blake, totally. Blake Lively, Justin Baldoni, let's do it. And that's how I got the original complaint. And then they just published a website and left it on there. I haven't had a need to go to Pacer, although I was going to sign up for Pacer this afternoon, but then I just found it on Reddit. I said, oh, here it is.
Yeah, all right. Reddit's good, dude. It's good. Oh, are you on which Reddit are you on?
It ends with lawsuits.
Yeah. There's there's a whole Reddit for these cases, but then there's also a Justin. There's also a Blake.
I saw the Justin one. I haven't seen the Blake Lively one.
Yeah, it's not very. It's mostly like fashion stuff, from what I could tell, but I haven't looked at it in a minute. So,
I'm totally looking at the fashion stuff.
Well, yeah, I figured because you want some inspo for your next big outing.
Yo,
so you need some outfits to
my
wear.
fashion is pretty basic, man. I'm a jeans and t-shirt type of guy. As soon as I'm out of court, I immediately change out of my suit and get into my jeans and t-shirt because I'm just that kind of a guy.
Well, yeah, there's plenty of room for ferrets in there, so
that's speculative.
Oh no! I accidentally said the truth. Okay. Anyways, how's your dad?
Oh, no. He might be looking for a nurse pretty soon, so he's taking applications.
What does it pay?
I think he pays you in blowjobs.
It doesn't work for me. I don't have a ferret magnet.
Well, he does the whole thing. You gotta wear an appropriate plastic appendage, and then like play it out like.
Do I have to pay? Do I have to pay for the plastic appendage?
Yeah, it's like a bring your own appendage type of deal.
I see. I can't do that. I can't commit to that right now. I'm just busy.
All right. So you're just we're changing terms. He must provide all appendages.
Yeah. I'll file a motion to amend the agreement or something. Whatever you guys do in law.
You know what? I'll stipulate to. You don't even have to file the motion. I stip.
But what about your dad? Doesn't he have to agree to it?
He doesn't have to do shit.
All right.
I'm his lawyer, and so therefore I speak for him.
So it says, where's the intimacy coordinator? Jacqueline Jackson, thank you for the $5. Will the depositions be public shortly after taken? And does this gag order ask them to keep from going public?
That sounds like it does.
Yeah.
Maybe not for all witnesses, but for most of them, it sounds like. For example, I think the people that have already been named in the complaint, namely the parties and well, really the parties. They may be made public, but then again, maybe not. It's probably safer to just keep them under wraps. Which is no
Safer,
harm.
but like less interesting.
Yeah, definitely less interesting. And
Anyways, H says it ends with subpoenas. So
with a penis, it ends with a penis.
oh, not for me. I tried that.
Don't give the company fuck about your moral conundrum, you
Oh, Mark,
meathead.
what the hell is happening over there?
That was my dad yelling at me.
I don't know what that was, but it wasn't your dad. I know what he sounds like. All right. Anyways. Okay, we'll kind of skim through the rest of this. All persons seeking to file redacted documents under seal with the court shall follow Rule 2H. No person may file with the court redacted documents or documents under seal without first seeking leave to file such papers. All persons are hereby placed on notice that the court is unlikely to seal. Okay, unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at
What are
trial.
we reading right now? Is this a proposal or is this a directive from the court?
Oh, this is I forgot to go back down. My bad. No, we're still reading the protective. Yeah, the protective.
Is it a proposed protective order?
Yes.
Or is it an actual protective order?
It says proposed. Yeah.
Okay, so according to this, not everything's going to be under seal. So that's good.
Okay. Dave, I don't know if you're still listening, but I just got your email and the answer is yes. I will invite you to my next ferret legging competition. That's not what he asked. No. Anyways. All right, let's see if we can find anything else interesting here. If not, there's just a bunch of legal jargon that I'm sure you can go over later if it's interesting. Because it's 2:30 and I have I have to wake up for work at 8.
Sucks.
Any PII, it's fine. I did this to myself, didn't I? Any PII exchange and discovery shall be maintained by the persons who receive such information and are bound by this protective order in a manner that is secure and confidential, including as addressed in paragraph 2E. In the event that the person receiving PII experiences a data breach, because people are going to try to hack them, aren't they?
This is like the Alex Jones when his attorneys turned over his entire cell phone when they weren't supposed to. And they didn't bother to object to it. And so therefore,
what?
He got hit with like a $3 billion judgment or something like that. It was the biggest, stupidest mistake that you could possibly make. It was literally a discovery request. And they had to turn over certain text messages on his phone. His dumbass attorney, maybe it was a paralegal, maybe it was like a low-level associate, proceeds to turn over the entirety of his cell phone. And they notified him, like, hey, dipshit, you might not have meant to send us this, but we have it. And rather than respond to it and say, oh, thank you so much for being honest, let me get that back, they just left it alone, which means they waived any objection. And they got to go through the entire phone, and the entire phone was admissible. And because of that, they were able to prove that he specifically lied about receiving certain text messages. And they called him out in front of the judge. And on cross-examination, the attorney specifically said, did you know that your attorney fucked up like really bad? That's how we know that you're a liar. And he proceeded to get like a $5 billion judgment or something like that. It was the Sandy Hook case.
God damn. No, I didn't. I didn't follow the legal case at all. I mean, what year was that again?
That would have been 2023 or 2024.
Oh, really? I thought it was way before that, but no, I wasn't following that at all.
Well, it was the Sandy Hook lawsuit. The parents had sued him because Alex Jones was saying a bunch of crazy shit.
Oh, no, I know that much. I was following like the news stories. I just wasn't following the actual lawsuit.
What was weird about it was that he had already lost on default. And so it was literally just like a prove up here. They're trying to prove damages. And so the whole exercise was like futile to begin with. But then, the big highlight was the big reveal that attorneys fucked up. And they violated their own rules. They failed to object to privileged information. And, rest is history.
Yeah.
Oh,
well, that's fantastic. Okay.
You're all covered up in your unicorn blanket over there.
Your girl's cold. All right. In Florida, it drops below 100 degrees at night. So, I'm very freezing right now. This protective order shall survive the termination of litigation. I went through that, actually. And then we got to the NDA. And this is Exhibit C, and it was like, what is this, like a draft, I think, of the proposed protective order?
By the way, it wasn't $5 billion. I remember it being in the bill. It was $965 million.
Gosh, that's
I just
almost
Googled
the
it.
same.
Totally. I mean, hey, I'd sell for $965 million. I don't know about you. If somebody gave me $965 million, I would disappear off the face of the earth, and I would do YouTube streams in a cave in Tahiti. I don't know why there, but somewhere where they have caves.
I'd like to watch that live. Anyways, somebody wants to know if you do an updated version on Sandy Hook.
Fuck yeah, why not? Yeah, why not? We could do a Is there anything new happening on the Sandy Hook case?
Not that I know of. Lauren, I just got a notification for a drop. Do I have something premiering now? What do you mean, Steph? People who are paid Patreon members, you get the video. The members only video just came out. That's why that is. But also, if you're a member of the YouTube channel, you get the same video, so you don't have to join both. Wait, no, I lied. You totally have to join both, guys. You don't. No, I'm just kidding. Anyways. I don't want to read through the whole thing just because it looks like this was some sort of draft or something.
Well, let's see. What are we looking at here? These are confidential attorney eyes only such portion. Well, this is all just a proposed judgment. So,
right. So this is like, it's the proposed protective order, but it's not the one that we just read. It's like a one that was.
Is it a competing proposed order?
Marked through and shit. Hang on, let me see. No, it says Exhibit C.
Oh, maybe that's the working version of their meet and confer, where they're like,
okay, that makes sense. Yeah.
Agree to and change.
Yeah. Okay. So say I'm sure as shit not gonna read that again. What's crossed out here? Any party who requests additional limits on disclosure, such as attorneys' eyes only and extraordinary circumstances, may at any time prior to the trial of this action serve upon counsel for the receiving party a written notice stating with particularity the grounds for the request. If the parties cannot reach agreement promptly, counsel for all parties will address their dispute to this court in accordance with paragraph 1C of this court's individual practices in civil cases.
Oh, looks like they want to remove that paragraph in its entirety. Rename paragraph 9 as 8. And 10
yeah,
is
but why? Like why? Like what is that?
Oh, what would be the reason why?
Yeah.
Let me read it. Whenever you read things,
sir,
glaze over. I don't know.
Yeah, I know because I do the same thing to you on your streams.
Like I gotta read myself. I'm going to comprehend. I don't know. Okay, any party.
We're both just like, people say like active listening and stuff. Neither one of us does that. We're like, okay, this person's talking now, so I have a time to take a nap.
I have to have 3 sensors on me at all times if I'm going to pay attention. It's just how it always has been. Any party who requests additional limits on disclosure, such as attorney's eyes only in extraordinary circumstances, may at any time prior to the trial of this action serve upon counsel for the received party a written notice stating with particularity the grounds for the request. If the parties cannot reach agreement promptly, counsel for all parties will address their dispute to this court. And the court, it's just, if you want to have extra protections for something else, then you got to address it in writing. If you can't agree, then we're going to have a hearing about it, and then the judge is going to decide. They don't want to go through the rigmarole, so they just took it out.
Rigmarole.
Totally.
I heard that. All right. Let's see if there's any. I don't see anything else that's crossed out that's like super substantial here. We got. That's the NDA. Okay. Yeah. Oh, that's the end of it. Oh my God, we made it to the end.
They're basically just saying like whatever this order is what it's going to be. There's not going to be any request for further litigation about expanding the order. So let's just get it right the first time. Take out paragraph 9.
Yeah. All right, everyone. Thank you for joining again. Thank you, Omar, for joining us. I was getting very tired and confused. But it's before 3 a.m., so I should get at least 5 hours of sleep tonight.
Hey, 5 hours is about what I average on a daily. You do it long enough, you could do it. It's just probably not good for your long-term health. So
no, but it's different. Like you're like a father and a practicing attorney. I'm just like a freak who's awake at this time of night to read a document on YouTube.
Man, I haven't slept.
This isn't even my fucking job. Like,
it is your job. You know what? I'm venture to guess that in sometime soon, in the coming days and months, that your YouTube income just might supplant your main job, and you might just end up doing this full time. It's going to take me a little bit longer to get there, because lawyer salaries are hard to replace. And so,
unless you're trash.
Unless you're trash, and I got to retire at some point. I'm trying to get to Bruce's level.
Oh man,
I'm
Bruce
deep into
has got it
investments.
going on,
And, I'm like rapidly trying to accelerate towards retirement within the next 6 years before I hit 50.
You should probably start by just like getting some chickens, because that's what Bruce did, and now he's retired.
My wife wanted to get some chickens. It's like, fuck,
is that
yeah.
true?
Yeah, she wanted me to buy a compound and like have goats.
Wait, you have a goat compound?
I don't have a goat. I know. I was like, goats, really? Do you know what they do to goats in like Brazil?
Well, no, Omar, I've never wondered about that. I don't know what they do to goats in Brazil.
This is special for your audience only. There is a documentary on Vice. I want to say it came out definitely when I was in law school, like 2012, 2013. It was South American boys. I want to say the country was Brazil, where it was normalized that they would have relations with donkeys. And then they would interview like the moms and the women in the village, like, I'd rather him do that than get some girl pregnant. It's like, oh, it's like, and they had like these films and like these bits of like these children, like talking up this donkey like it was a woman. And then like having relations with the woman. At the very end of the documentary, some guy who's been doing this for years, like did a demonstration for the Vice filming crew. And they were disturbed. I think some of them were like welching, wanting to throw up. It's a fascinating hour watch if you have the time.
Well, I have to be in the car with my family for 5 hours tomorrow. So,
put that on the Bluetooth.
Remind me to look that up. Oh, man. All right, everybody. Thank you for being here. I appreciate you. I got to go to bed now. So,
all right, Lauren, you get your rest, man.
Yes, thank you. I appreciate you. You're always here for me. And I feel like I keep missing your streams, but I do mod the chat. So I promise.
No, I do appreciate the modding of the chats for sure.
I know you don't read the chats very
I try my
much.
best, man, but I get so like fired up and just like lost in whatever I'm doing.
No, there's like a few trolls. There's a few trolls that come in these streams, and I just love trolling. So I'm like, all right, this is a challenge for me. I accept this.
There's no troll who is safe when Lauren is in my stream. I know that.
Yeah, well.
Sure. Anyway, I'm really
proud
of you.
We like a little thrill, a little danger.
Hell yeah.
All right, bye guys. Thank you. I'll see you soon.
All right, Lauren, you get some rest.
Yeah, you too. Bye.